appeal in the matter of Burrell and the Royal Bank of Scotland PLC.
Thank you. Mr Taylor.
May it please your ladyship and my lords, I appear on behalf of the Royal Bank of Scotland PLC with Mr Giles Robertson. Mr Robert Weir QC appears with Mr James Butters on behalf of the respondents Mrs Smith and Mr Burrell. These are second appeals that are from decisions of His Honour Judge Gore QC in the Exeter County Court on the 13th of November 2000 and His Honour Judge Murdoch on the 20th of April 2021 sitting in the Northampton County Court. Just some brief background as to why these cases are before the Court of Appeal. They arise out of the well-publicised historic mis-selling of PPI policies. Between 1990 and 2010, tens of millions of PPI policies were sold in the UK. As the Court will know, the FCA put in place rules which required banks to operate a redress scheme to compensate customers for the mis-selling of PPI. Those rules first came into force in 2010. In 2014, there was the decision of the Supreme Court in the Plevin case, which is central to this litigation. Following Plevin in 2017, the FCA amended its rules to require banks to provide redress in Plevin cases. Both of the claimants in this case went through that redress scheme and were paid compensation in accordance with the rules applicable to the banks, the DISP rules they're called. The last date for customers to make complaints about PPI mis-selling under this scheme was the 29th of August 2019. That was a date which was the subject of nationwide publicity both by the FCA and indeed claims management companies. Since that date, claims management companies such as those behind these two claims have moved their focus away from the FCA mandated redress scheme onto the county courts. These claims are funded by claims management companies who work on a success fee, usually taking a percentage of the recovery in the region of 40% plus VAT. The bank's solicitor, Mrs Gillies, has explained in her witness statement when seeking permission that the bank is now faced with thousands of claims in the county court in which consumers are bringing unfair relationship claims, just like those brought by Mrs Smith and Mr Burrell. In November 2020, there were 950 claims against the bank. Those were increasing at 100 cases per month. Mrs Gillies also explains that similar claims are being brought against other banks. The press reports refer to the possibility that millions of customers may bring such claims. The burden on the county courts is obviously significant. These cases raise 2 points of principle. The bank has won some of these points before the county courts and it's lost these points before the county courts. Hence it brings this appeal in respect of two cases it lost. On the 9th of March 2021, Lady Justice Asplin gave permission to appeal for a second time in this case of Smith on the basis that it raised important points of principle, noting that there was no High Court or Court of Appeal authority in relation to the interpretation and effect of the relevant transitional provisions or the application of the Limitation Act 1980. Ground one of the appeal in Smith concerns pleading points taken by His Honour Judge Gore QC of his own volition.
They're not going to bother us, are they?
No, I'm grateful, lady. I'll move straight on.
No. Well, I think the very, I may say so, realistic appraisal of that point by the respondent.
I'm grateful.
We need to get to what matters.
Indeed. Finally, just by way of background, on the 23rd of June 2021, Lord Justice Bean gave permission to appeal for a second time in the Burrell case, recognising the importance of these 2 points that are before the Court of Appeal. Key facts. There are no material differences between the facts of the Smith and Burrell cases. In Smith, she took out her PPI policy and credit card agreement in January 2000. Her PPI policy ended in April 2006, with all the balance on her credit card referable to PPI paid off on that date. Mr Burrell took out his PPI policy and credit card in 1998. That ended in March 2008. Again, all balances referable to the policy were paid off on that date. His credit card continued. Deputy District Judge Crowe found that the adverse financial consequences of the claimant, for the claimant in that case, must have ended in 2000 when the PPI policy ceased to exist. And the effect of the lower court's rulings are that the bank has been ordered to repay sums that Mrs. Smith paid for her PPI policy between the year 2000 and 2006, sums she paid between 13 and 19 years before the claim form was issued in August 2019. As regards Mr. Burrell, the consequences of the decision on the preliminary issues in that case is that the bank is now exposed to a claim to repay sums that he paid for his PPI policy dating back to the previous century, 1998, 21 years before he issued his claim form in 2019. So, the first point of principle, the effect of the transitional provisions and the legislative purpose behind those provisions. Just before I move on to the materials which show the purpose, if I outline the two main points which we make in relation to the transitional provisions, perhaps if we turn up section 140A of the Consumer Credit Act, which is in bundle 1. Tab 3. Bundle 1, tab 1, page 9. Section 140A applied to the relationship between the bank and Mrs. Smith and Mr. Burrell on the 6th of April 2008 onwards. That's the first time it came into effect between those parties. At that time, only the credit card agreement was in force. Now, there's nothing about the relationship arising out of that credit card agreement alone which is unfair. So there is no basis for ordering any sums under section 140B. That's the first point, in summary. Alternatively, if the statute permits the court to consider the historic PPI policy, which had no effect on the credit card on 6th of April 2008 onwards, in order to determine if the current relationship is unfair, then it is common ground that the PPI policies cease to have any operation before the 6th of April 2008, and Schedule 3 of paragraph 16 requires the court to read the remedies in section 140B as having excised the words paid by virtue of the related agreement. In other words, paid by virtue of the credit card agreement. And we say that all the PPI premium and interest were paid by virtue of the PPI policy and are therefore irrecoverable under Schedule 3, paragraph 16. Now, in our scales of argument, we have set out some of the background materials to the legislation that introduced the Consumer Credit Act 2006.
You have. Can I just ask a question about that? Both of the appeals obviously raise similar points, and there are two skeleton arguments from each of you for obvious reasons. But are we to assume that, for example, Smith is the leading case in terms of the contents of the skeletons?
Yes, that's fair, my lady. It is the leading case in terms of the skeletons, although the shorter skeletons in some ways actually might be more focused on what the issues are between the parties.
So when you're referring to the skeletons, if you say Smith or Burrell as necessary, otherwise we're going to assume it's Smith.
I will demolate it.
All right.
I will. So this is Smith's skeleton, paragraph
Thank
29. Refers to some of the background material to the Consumer Credit Act 2006, which introduced sections 148 to B. The principles on which we say these materials are admissible, I do not believe to be in dispute. They are in Benion at the second authorities bundle, AB2, page 657. Tab 29 of the authorities bundle.
Thank you.
Page 657, paragraph 2412. Benion. Reports of legislative debates may be referred to outside the rule in Pepper and Hart to supply context or identify the mischief at which legislation is aimed. This section is about the use of reports of legislative debates outside the rule in Pepper and Hart, the use of reports of legislative debates in accordance with the rule, see Code 2411. There is a growing tendency for courts to rely on legislative debates on a bill, not as an indication of legislative intent in resolving ambiguity as to the meaning of a particular word or phrase, but rather to supply context or identify the nature or extent of the issue at which legislation is aimed. To this extent, the cases seem to provide support for a wider relaxation of the exclusionary rule, relying on parliamentary materials outside the conditions laid down in Pepper and Hart. For example, in Lord Mann said, in recovery of medical costs for asbestosis diseases case, to put a legislative measure in context, domestic courts may, under quite distinct from that in Pepper and Hart, examine background material, including a white paper, explanatory department notes, ministerial statements and statements of members of Parliament in debate. If one moves on to paragraph 6, page 659, another paragraph of Benion, it's marked in the left-hand margin. Explanatory notes to an act may be used to understand the background to and context of the act and the mischief at which it is aimed. Other explanatory material provided by the promoter of a bill or amendment for the use of members of the legislature is likely to be treated in the same way if it is also made available to the public at large. But it is not appropriate to have regard to explanatory material as an aid to construction if it is not publicly available. All of this material that I'm about to take you to is was publicly available. The first, if we could put away, well, we can actually turn to the explanatory notes to the Act, which are at tab 32 of the file we're in. And it's page 715. These notes, as they state on the front, are their explanatory notes to the Consumer Credit Act 2006. We need to move on to page 724 to see what was said about the transitional provisions and savings. Again, this is marked in the left-hand side. Schedule 3, which is the provision concerning the transitional provisions introducing this new claim for unfair relationships into the law. The notes say this. Well, in fact, if I can invite the court to read, please, paragraphs 110 through to 112. In particular, the very final sentence of paragraph 112, the transitional period will allow creditors to ensure that any agreements that will continue beyond the end of the transitional period comply with the amended 1974 Act. In other words, lenders were given a 1-year period of time in which to bring their credit agreements and the related agreements with them into compliance with the new law, the new Unfair Relationships Law, which came into force on 6th of April 2007. It was from that date, 6th of April 2007, that there was this transitional period of 1 year until 6th of April 2008. And that was to allow creditors, as I say, to get rid of the unfair agreements or practices around their lending, give them a chance to put their house in order so that they would not then face claims under section 140A to B if they did that. To similar effect, tab 33 over the page are the questions and answers on the Consumer Credit Bill, which were published by the DTI, which was the department which promoted this bill. And at page 732, similar comments are made that the new unfairness test will have some retrospective effect. The new unfair relationship test will apply to all new credit agreements made after the date that the reforms commence, and will apply to any agreements already made which continue in existence at a specified date after commencement. We will consult with consumers and the industry as to when this date will be. The period between
I missed that paragraph that you're looking at.
Sorry, it's page 732, maybe, paragraph 13.
Thank you, yes.
The period between the commencement date and the specified date will be a transitional period to allow creditors to ensure that any agreements that will continue beyond the end of the transitional period comply with the new test. The old test will continue to apply to agreements that have been completed, e.g. no party has any further obligations under the agreements because no further sums are payable before the end of the transitional period. The new unfair relationships test will not apply to those agreements. And then finally, we have the statement of the Minister in the House of Lords when the bill was at the committee stage, and that's at tab 31. And this was a statement, tab 31, page 709. This was Lord Sainsbury. And if I might just invite the court to read from the passage on page 709, which starts with Schedule 3 at paragraphs 14 to 16 provides until the first paragraph on page 711. But noting in particular just the words right at the start of the passage I've invited the court to read, which is talking about Schedule 3 at paragraphs 14 to 16. That is a reference to the schedule of the Act concerning credit agreements which have come to an end before the new law came into force, and related agreements that ended before the Act came into force. And I will come on to that. I'll take you to the schedule. But it's important that this statement was made in relation to both credit agreements and related agreements in our submission. And I'll just highlight the paragraph on page 710, which says, it's the middle paragraph, in deciding which agreements the new test ought to apply to, if considered the carefully of the interests of all sides on this issue. As I've explained, the new provisions will not apply to agreements that end prior to the completion of the transitional period. This gives some certainty for lenders that agreements ending before the end of the transitional period cannot be challenged. But there must be a point at which the new test will apply, and the new test will apply to all agreements existing and carrying on after the date that the transitional process ends. It will apply to them without any limitation. Now, in our submission, the purpose of these transitional provisions is absolutely clear from all of these materials, that there was a period in which lenders were effectively allowed to get their house in order so that they would not then face claims under section 140A to B if they did indeed put their house in order and got rid of unfair agreements or related agreements. Now, section 140A came into force on the 6th of April 2007 and introduced for the very first time the unfair relationships legislation. The way in which it was implemented is in Schedule 3 to the 2006 Act, and that is at the Authorities Bundle AB1 tab 3, page 29. Starting with paragraph 14 of Schedule 3, which is headed Unfair Relationships on page 29. The effect of this, before we read it, is that if an existing credit agreement, an existing loan, ended before 6th of April 2008, then it was not subject to this new law on unfair relationships. And the way the statute did this is in this way. Section 14.1 says the court may make an order under section 140B, that's the remedies section, in connection with a credit agreement made before the commencement of section 20. And you can add in the date there, that's the 6th of April 2007, so that's when that came in. But only on an application of the kind mentioned in A. That's basically an application by the debtor. If one then drops down to 14.2, there is a proviso, but the court shall not make an order in connection with such an agreement so made if the agreement became completed before the commencement of section 20, and one can write in there the 6th of April 2007, or becomes a completed agreement during the transitional period, and one can there write in the 6th of April 2008. So in summary, the effect of section 14.1 was to say that if there was an existing loan that ended before the 6th of April 2008, then it was not going to be subject to the unfair relationships legislation. That's the effect of section 14. A completed agreement, just to make that good, is defined in paragraph 1 of this schedule, which is on page 26, which says that there is no sum payable under the agreement, and there is no sum which will or may become payable.
Sorry, Mr. Taylor, I missed that page reference.
Yes, it's page 26, my lord. And that gives you the definition in subsection 2 of paragraph 1 of completed agreement. And that is that there's no sum payable under the agreement and no sum will or may become so payable. That's a way of saying that the existing loan agreement has basically ended.
Yeah. But of course it would have been much too straightforward for them to have said that.
It is somewhat convoluted, my lord. It is.
As I understand it, Mr. Taylor, the one trying to defend the parliamentary draftsman for 10 seconds, the one thing that this is trying to do is make sure it doesn't just cover the example you keep referring to about one loan coming to an end, but also deals with a credit card agreement, which there may be no loans outstanding as at the relevant date, but there's going to be, will be or become payable things in future.
Absolutely right.
Which is why the credit card agreements in your case don't count as completed agreements on their own at that point, even and no one cares what the credit balance was at any particular time, and that's what they're trying to catch, or one thing they're trying to catch.
That's absolutely right, my lord. That's right. So section 14 deals with existing credit agreements, i.e. agreements that were in place when the Act came into force in April 2007. Section 15 deals with extortionate credit bargain legislation. I don't think we need to look at the details of that as to how that's affected, but it is affecting the transition from extortionate credit bargain legislation, which was the old law, to the new law under section 140A about unfair relationships. Paragraph 16, though, is important in this case. And this is dealing with what are called related agreements. Now, there is no dispute in this case that the PPI policy was a related agreement. Very briefly, the reason for that is that it was a linked transaction under section 19 of the Consumer Credit Act. And very broadly, that's because the PPI policy was funded by the credit card. Now, I can go through the detail of that, but it is common ground between the parties that PPI policy is a related agreement. I don't propose to take up the court's time unless it wishes to go through the steps of the Consumer Credit Act in order to reach that conclusion. Now, for related agreements, the transition to the unfair relationships regime was affected by paragraph 16(4). And if I might invite the court to read, please, paragraph 16(4). And indeed 16(5). Just placing some dates on paragraph 16(5) before we look at 16(4). Subparagraph 5 says, subparagraph 4 applies to a related agreement or security if it was made or provided before the commencement of section 21, and we can write in there the 6th of April 2007, and it ceased to have any operation before the end of the transitional period, and we can write in there the 6th of April 2008. So, in short, a related agreement which falls within subparagraph 5 is one which ceased to have any operation prior to the 6th of April 2008. If it satisfies that criteria, then subparagraph 4 is applicable. So you have a related PPI policy which ends before the 6th of April 2008, so therefore we're into the territory of section 16(4). And what that provides is that when one reads section 140B, as it says in paragraph 4A, references in subsection 1 of that section to any related agreement shall not include references to a related agreement to which this subparagraph applies. That is effectively saying you ignore, you excise the words related agreement. And it goes on to say that under paragraph G of that section, the court cannot order accounts to be taken between the parties in relation to such a related agreement. Now, in order to understand section 16.4, we need to look at section 140B to see what it's telling us to do. And section 140B is on page 10 of the bundle. And if one takes paragraph 140B 1A, this has to be read by excising out references to the related agreement that has ended before the 6th of April 2008. So reading 141A, which is the crucial section for this case, an order under this section in connection with a credit agreement may do one or more of the following: require the creditor or an associate or former associate of his to repay in whole or in part any sum paid by the debtor or by a surety by virtue of the agreement, and then one excises, or any related agreement. So it's saying that where you have a related agreement that has ended, or has ceased to have any effect in the words of the statute, before the 6th of April 2008, then you ignore, you excise those words from the powers that the court has under section 140B 1A, and it can only order sums that were paid by virtue of the credit agreement, which continues. Section 16.4 also made express reference to 141G, and section 16.4 says in terms that the court also cannot order accounts to be taken in relation to a related agreement that ended before the 6th of April 2008. So the way in which section 16.4 works of Schedule 3 is to tell the court every time you read the words related agreement in section 140B 1A and all the other subsections there, which are various different remedies, you read it as if a reference to the related agreement is not there. But special provision had to be made in respect of subparagraph G because it doesn't actually refer to related agreements, and paragraph 16.4 there says that when a court makes an order under section 140B, the order shall not, under paragraph G of that subsection, direct accounts to be taken in relation to a related agreement. The court can't order that remedy either in relation to a related agreement.
So the only reason that that's an additional provision is because the words any related agreement aren't in G.
Precisely, Lord. Now, in our submission, the intention behind this legislation was that no remedies should be ordered in respect of a related agreement which ceased to have effect, i.e. ended before the 6th of April 2008. And that would obviously include a situation where the related agreement was unfair and was the cause of a previously unfair relationship. That's the whole point of this. Now, in these two cases before the court, the sole cause of unfairness was the PPI policies under which the customer was paying an insurance premium each month, not knowing that the bank was receiving a commission. But in both of these cases, that unfair PPI policy ended before the 6th of April 2008. In the words of Schedule 3, paragraph 16, they ceased to have any operation prior to 6th of April 2008.
Well, they were completed agreements.
Well, there is a difference in wording between the way in which the statute deals with loans, credit agreements,
Right.
which has the concept of completed agreements, and then related agreements are dealt with by reference to whether, in the words of 16.4, they cease to have any operation.
And so that they're defined as, what was the terminology you used?
What the related agreements?
Yes. If it's not a completed agreement, what is it?
It is a in subsection 5 on page 31 of the bundle, it is a related agreement which has ceased to have any operation before the
Right.
end of the transitional period.
So inoperable.
Yes, that's yes.
Okay. Is there a difference
Uh,
in reality?
well, in my submission, there is no difference between whether an agreement is a completed agreement or has ceased to have any operation.
Right.
Except perhaps in this situation, and we will come on to this because this is relevant to some of the cases that my learned friend relies on. It might be possible for a related agreement to have ended prior to the 6th of April 2008, but the financial consequences of that might be continuing in another agreement, i.e. the credit agreement.
Can you give me an example of that?
To give you an example, let's assume that there is a loan under which required a PPI policy to be bought, say in 2006. A £10,000 loan and it required £1,000 to be paid for a PPI policy, which lasted 1 year.
Yeah.
Now that PPI policy comes to an end in 2007, say, before the Act comes into force, but the amount that was paid for the premium is still extant on the loan agreement. So the money's been borrowed, but it hasn't been repaid. Now, it might be said that, well, the related agreement had not ceased to have operation on the 6th of April 2008 because there was a sum referable to it on the loan.
Right, okay.
That is not our case here. There are no sums referable to the PPI,
Yes.
which continued after the 6th of April 2000. There was nothing on the credit cards referable to.
But you can envisage that there may be some.
There might be a situation, and then there would be an argument that, well, that would be, it would be said that, well, the unfair PPI agreement didn't cease to have operation, for example. That might be an argument that's wrong. So that doesn't arise for this today. Now, if we go to section 140A, which is at under 1 tab 9.
Page 9.
page. I'm sorry, my lord. It's page 9. Now, by virtue of the provisions that we've just looked at, the transitional provisions, the first date that this piece of legislation applied to the relationship between the parties is the 6th of April 2008. And it's applied because the credit card agreements were still running. But both the PPI policies had ended. So as at 6th of April 2008, one reads this section, and in our submission, what the claimant has to do is show that the credit agreement is unfair as at the 6th of April 2008. That is the only agreement that was in force at that time.
Does it matter whether you ask the question that way or ask whether the relationship is unfair?
The relationship, no, it doesn't matter.
It's about unfair relationships, not unfair agreements.
You're absolutely right, my lord. It is the relationship that has to be unfair, and we say that has to arise out of the agreement, i.e. the credit agreement, not the credit agreement taken with any related agreement, i.e. a PPI policy, because the PPI policies have gone. They're not there anymore, they don't exist. Now, the credit card agreements are perfectly fair. They're ordinary credit card agreements, which millions of people have. No one says that those agreements on their own create an unfair relationship.
Well, some do, but
Well, not yeah. Well, some
but they wouldn't come before the court.
no, So what we have on the facts of this case, we say, is we had a situation which was envisaged by the legislation that unfair related agreements would come to an end before the Act came into force, and all that would remain is an existing credit agreement. That credit agreement, the credit card, is fair, and there should be no remedies available to the credit card holder under this legislation, because the relationship from the 6th of April 2008 was fair. So, on the facts of these cases, the claimants can't satisfy the criteria in section 140A to show that on the 6th of April 2008 onwards, the relationship arising out of their credit card agreement was unfair. Now, my learned friend relies on Schedule 3, paragraph 16.1. Which is on page 30. Paragraph 16.1 says, it is immaterial for the purposes of section 140C4A, that's the definition of a related agreement, of the 1974 Act, when, as the case may be, a credit agreement or a link transaction was made or a security was provided. Now, that's a long-handed way of referring to related agreements. Linked transactions are related agreements. So one can read that as saying it is immaterial for the purposes of the definition of related agreements when that related agreement was made. Now, what this doesn't say, though, is that it is irrelevant when it ended. That, in our submission, is highly relevant as to when it ended. And so, on the facts of our cases, the related PPI policy ended before the 6th of April 2008, and that results in the conclusion in our submission that section 140A1 is simply not satisfying in this case. And standing back, that is the right result, because the relationship is fair from the 6th of April 2008 onwards. No one would expect a statute to give a remedy for historic unfairness arising out of a contract that ended before section 140A came into force. But that's precisely what the claimants in these cases have to do to get their case off the ground. They have to, what they do is they go back in time prior to section 140A coming into force to refer to a PPI policy that had ended before section 140A came into force. All that shows is that there was an unfair relationship, but the statute requires that from the 6th of April 2008 one has to show that the relationship is unfair to the debtor. And the claimant's interpretation of this statute produces what we respectfully suggest are surprising and absurd results. If one takes their skeleton, Smith's skeleton, paragraph 52, they give an example in paragraph 52 of the purchase of a timeshare with a credit card, where they say the timeshare agreement will be a related agreement. And if the debtor then pays the balance of the timeshare partly on its credit card and partly not, what they say is that the amount will have been paid by virtue of the credit card, and once the court has found that the relationship between the debtor and the creditor is unfair, the court can order the creditor to repay not just the deposit paid by virtue of the credit card agreement, but also repayment of the balancing sum which was paid only by virtue of the related agreement or some other to some other person on the credit. So what they're saying is, give a real life example with some dates on this. Imagine that someone took out a 1-year timeshare in 1990, which they paid for on their credit card. They discharged the debt on their credit card by making a monthly payment in the usual way. Imagine the terms of the timeshare are unfair. For example, they gave the property owner the right to cancel all bookings of the timeshare without any recompense. Imagine the timeshare comes to an end after 1 year in 1990. The owner of the property has cancelled all the customer's bookings, they paid for it and got nothing. The timeshare agreement comes to an end in 1990 after 1 year, but the credit card continues. Now, on the claimant's analysis, on the 6th of April 2008, when the credit card became subject to section 140A to C, the court can go back to the 1990 timeshare and find that the relationship on the 6th of April 2008 is unfair because of what happened historically.
I'm sorry to interrupt, but it was a bit difficult when the case that you've set out in writing is being misrepresented. And if you go to paragraph 52, you'll see the way in which we framed it was to set out in the second sentence, in a case governed by sections 140A to C and not involving the transitional provisions. In other words, we were giving an example of what would happen in an example after 2008 as opposed to an example in 1990. That's the full scope, which has then been attenuated, not the way round that it's being put.
Well, as I understand what my learned friend is saying. He's saying that the sum paid back in 1990 by the credit card would be recoverable. I think he's nodding. So the example that I gave is, in 1990, a consumer purchased a one-year timeshare agreement using their credit card. It turns out that the relationship is unfair because of the terms in the timeshare agreement, which allows the timeshare provider to provide no service but keep the money. On my learned friend's argument, on the 6th of April 2008, when the credit card became subject to section 140A to C, the court could go back to the 1990 timeshare contract, find that the relationship on the 6th of April is unfair because of what happened back in 1990, and can then order the bank to repay the amount that was paid on the credit card for the 1990 timeshare. Now, if I've got that wrong, no doubt my learned friend will tell us, but that is what he's saying.
Well, I read this paragraph to the effect that an extreme example is given to indicate the extreme reach of sections 140A to C when the transitional provisions are not engaged.
Well,
and he goes on at the end to say the court can order the creditor to repay not just the deposit that was paid by the credit agreement or the related agreement, but also the repayment of the balancing sum, which was paid only by reason of the timeshare. So he's just saying, look how wide this provision is, so why shouldn't it be as wide when we look at the transitional position?
Quite a lot. It's showing that section 140B's attenuation in paragraph 16 of Schedule 3 is real, because it would not allow, when the events took place before 2008, recovery of payments which are by virtue only of a related agreement.
Right.
And you can get payments which are by virtue only of a related agreement, and those include the balance of the timeshare payment not paid under the credit card. So that's why I had to interrupt, because it was being put back to front as opposed to... It may be issue of uncomfortable drafting in paragraph 52, which I'm sure I should reflect on, but that's the substance of what...
That may be, but we won't go there yet. But so that's the point.
Well, it is really, but what, in my submission, we need to take from that is that where the payment was made by credit card, then my learned friend's case is that under the transitional provisions, the effect of the transitional provisions is that the money paid by credit card back in 1990 can be recovered. And that's what he says his interpretation of the transitional provisions is. And we would say that is an absurd outcome, given what we saw for the background to this legislation, that creditors were given a period of time to get their houses sorted out, get rid of unfair agreements, and there won't be any remedies against you. Yet, on their case, the 1990 timeshare agreement suddenly, because it was simply paid by a credit card, on the 6th of April 2008, then becomes subject to the Act, and the court can start making orders in respect of the sum paid by credit card for that timeshare.
Mr. Taylor, the bit of this that you haven't mentioned, which at least speaking for myself I think is important, or may be important, is that in the example you've just given, that is what you say the consequence of your opponent's argument is, but it does require a finding on proper grounds that in 2008 the relationship is unfair. And if in 2008 the relationship is unfair, then your opponents say that that is a consequence, but they don't say that if a relationship is not found to be unfair in 2008, that's a consequence.
Well,
so it isn't as simple.
I
I know you say it's wrong. I completely understand that you say that it would be wrong to say that the relationship was unfair in 2008 as a result of a 1990 timeshare. I get that. But I think, to be in fairness to your opponent's argument, that's a step in the logic which needs to be taken into account.
Well, my lord, the
Is that not? Do you understand what I'm saying?
I absolutely understand what you're saying, my lord. But what my learned friends say is that the unfairness is generated by the timeshare contract.
Sure, I understand.
That's what they say.
But if there were, my point is in terms of the legal provisions, is if on the facts it was right to say that in 2008 it was an unfair relationship, and I know you say it's wrong, I get that, but I don't hear you say that if it was right in fact that it was an unfair relationship in 2008, their consequences are wrong.
That's right. But my lord, if there is an unfair relationship in 2008 arising out of the credit card agreement, then
Yes. And even if the payment was in 1990, you accept it would be caught if it was a payment under the credit card agreement.
well, if it was, if the relationship was unfair, and that payment was made as a consequence of the unfairness, that's what they say, Lord, and we say that's simply not the facts of.
I understand. I understand you do say that.
I think, Mr. Taylor, speaking for myself, I always have trouble with these analogies very often because I'm struggling to understand the facts of the particular case we have to decide rather than the analogies. On your case, this case, these two cases are extreme. You've got claims going back to the last century.
Yes.
By relation to agreements that long since finished.
Yes.
Speaking as a common lawyer, that would seem and sound surprising. You say that that's why these claims are wrong. So speaking for myself, I'm just interested in why you say these claims are wrong, not the various analogies that doubtless pepper the skeleton arguments, but don't, to my eye at any rate, make this case any the less odd looking.
I'm grateful for that, my lord. So putting it in terms of the facts of our case, on the 6th of April 2008, the credit card became subject to this act. The credit card is perfectly fair. There's nothing unfair about it. It's never been said the credit card on its own is unfair. What is said to be unfair are the PPI policies that ended before the act came into force. And it is my learned friend's case that when assessing whether the relationship on the 6th of April 2008 is unfair, one goes back to look at those unfair agreements that ended. And you say, look, there was some unfairness a couple of years ago. That renders the relationship now unfair. And so therefore, I'm entitled to go back and recover all of those monies that were paid pursuant to this unfair relationship. That's their case.
So it's once unfair, always unfair. That's what the respondent's case is.
Once unfair in the past, always unfair going forward. That would be one way of characterising what they're saying, the lady. Yes. Yeah. Despite the fact that the agreements have come to an end, the PPI policies have come to an end. All of the cases relied on by the claimants where a PPI policy has been found to render a relationship unfair are cases where either the PPI policy continued after the 6th of April 2008 or the effects of the PPI policy were still reflected in the ongoing credit agreement. So, putting it another way, if they can say, oh look, my existing credit agreement includes a sum of money which is referable to an unfair PPI policy that I paid for 3 or 4 years ago. They'll say, look at my credit card agreement, it's inflated, the balance is inflated by £1,000 because of that payment I made back in 2006. Their case is not that case. The facts of this case is that all financial consequences of the PPI ended before the 6th of April 2008. So just to take an example of cases which have held that the relationship is unfair as a result of a PPI policy entered into before the Act came into force. Plevin Claimant was a case where the PPI policy and the loan were entered into on the 11th of March 2006, but they continued beyond the 6th of April 2008. The PPI policy continued. In the words of section 148, the credit agreement taken with the related agreement meant the relationship was unfair. Now,
we're not concerned, as you say, with such cases where nobody's taking any issue that if the PPI was continuing after the 6th of April 2008, that falls to be considered by the courts if there's no redress.
Yes, Mary, that can be taken into account in determining whether the relationship is unfair if it continues after the 6th of April 2008. Yep.
Yes, quite.
Yep.
But you're telling us that the respondents' cases don't include, as it were, the facts of these cases.
Yes,
their
that's right.
authorities don't.
Yes.
So one of the things that you've mentioned on a couple of occasions is the situation where there is some continuing effect of the PPI, although the agreement is finished, because it's one of those credit cards that are never paid off. It's only the minimum payment paid off. So there's always a debt outstanding. And somebody comes along to court and says, well, the PPI may have finished in March of 2007 or even earlier, but in actual fact, I'm still bearing the brunt of it because I've never been able to get to the bottom of my debt. So what do you say about that?
Probably. What they would then say is that their current relationship under the credit card is unfair because it is inflated by...
I know that's what they're saying.
Yes,
what do you say?
Well...
what does the bank say? Do you agree?
Well, lady, that is based on the authorities, something that they could say gives rise to an unfair relationship.
Right.
And they could seek redress for that.
So that's a recognised issue that doesn't arise in this case. That's
right.
Recognised, as it were, point.
That is recognised in the Barnes case that I will come on to.
All right.
Now, in fact, maybe just to show you, this is the high watermark of Maloney Friends case. And it's a bundle 2, tab 23. It's a decision of Judge Waxman, now Mr. Justice Waxman, in 2011 in the Manchester Mercantile Court. And it's important to understand the facts of this particular case, and those are set out in paragraph 3 of the judgment on page 435. And it basically involved 3 loan agreements. 2 entered into, all of them entered into before the Act came into force, and one of them continuing after. Just moving on to paragraph 4, where the judge said that there are still monies owed under the 3rd agreement which remains extant. So what we had on the facts of this case were 3 loans. The first 2 included within their balance PPI premium, and they were rolled up into the 3rd loan agreement, which paid off the earlier two, so that the third agreement contained PPI premium that had been paid on previous PPI policies. So the third loan included sums referable to PPI policies. And those first two loans are, because they were paid off by the third loan, fall within the definition of related agreements. So the borrowers could show that on and after the 6th of April 2008, the relationship arising out of that third loan agreement was unfair. And this illustrates the point that a borrower can say that their current relationship is unfair because of things that have happened in the past. So the claimants in that case could go back in time and point out that the balances in the two earlier related loan agreements included PPI premium, and that was still within their current agreements. So they could say, look, my current agreement, which is governed by the Act, is made up of quite a large part of PPI premiums that have been paid. Now, that is unfair.
Did they need to do that? Because the first two loans are subsumed into the third, and the third one required a further PPI policy. It only matters, I suppose, in terms of the remedy that you seek.
Indeed, that's absolutely
rather
right.
than the
Absolutely
trigger.
right. They could have claimed the PPI policy for the third agreement, which was in force after April 2008. They could have done, but if they wanted to claim other sums paid historically, they needed to show that those were included in the current balance and unfairly inflated the current balance.
Yeah.
Now, those are the facts which, in my submission, distinguish our case from the Barnes case. And there are some passages which are quite helpful in showing what Judge Waxman was cognizant of when he was making the decision that he did, that that claim could be taken forward to trial. At 64 and 65, he set out what he was considering, and he summarises the position in paragraph 64, which was common ground. Should I just invite you to read 64, please? And 65, because the issue in the case was that the bank there argued that you could not have any regard to what had happened in the past when determining whether the relationship now was unfair. It's what Mr. Justice Waxman described as the section 140A exclusion. The contention was you just cannot take into account anything that has happened prior to this loan coming into force. And the judge held that you can take into account historical events, but only if they show that the current relationship is unfair. And that was the argument of the claimants in 65, but the Barneses contend that when considering whether the relationship arising out of the third agreement is unfair, the court can still take account of the earlier two in the sense expressly permitted by section 140A. And paragraph 67, just invite the court to read 67 up to E, please. And it's in particular the words, when he was referring to another case, the Soulsby case, it's the words between D and E where he said, the pleading in the Soulsby case does not suggest, as a further alternative argument, that the relationship arising out of the third agreement was unfair, taking into account the earlier agreement. So what the judge was saying was, in deciding whether the relationship now is unfair, I can take into account what has happened in the past and why it is that the balance on the current agreement is the balance that it is.
And you don't take exception to that?
Well, lady, the Court of Appeal in the Scotland case we'll come on to makes clear that in determining whether a relationship is fair or not, one takes into account all the facts and matters that have arisen in the relationship. So one can go back in time to determine whether today's relationship is unfair. In the context of our cases, there is nothing which makes the relationship arising out of the credit card unfair. There's no consequence of PPI on the credit card agreements after the 6th of April 2000.
But if there was, you would accept this principle?
Well, I wouldn't accept it, lady. I can see there would be an argument about that.
All right. I can understand you're saying it doesn't apply in this case, but there are important issues that arise, not directly related just to the facts of this case, or this appeal.
That's right, lady. And finally, just on paragraph 75, where it's the first 5 lines where the judge says that said that the focus is still on the current agreement. The early agreements come in only as an adjunct to that focus. Now, what Section 140 doesn't permit is for a perfectly fair credit card agreement to be turned into an unfair relationship by referring to an historic related agreement that ended before 140A came into force and which has no effect on the fairness of the relationship from the 6th of April 2008 onwards. But that is what the claimants in this case are trying to do. PPI policies ended before the 6th of April 2008. No balances referable to them continued after that date. The only relationship in existence after that date was generated by the credit card, and that was fair. And when Section 148A came into force on the 6th of April 2008, it should be construed as referring to the relationship at that time, i.e. the credit card relationship.
I'm sorry to sound like a cracked record on this point, but I just want to see if you can bring yourself to make this concession that on your argument that would permit someone whose PPI agreement ended prior to that date, who nevertheless had ongoing financial consequences arising therefrom in terms of the credit card, would be able to bring a claim.
On the basis of Barnes, yes, my lady. That
Yes,
is what
so
Barnes
you
says.
can make that concession.
That's what Barnes
Yes.
says, my lady, yes.
Right. So it's sometimes possible to make concessions and improve your case.
Yeah, no,
rather than
yes,
otherwise.
absolutely.
That's, I'm not
that's
saying that's necessarily so in this case, but it's sometimes good to make a concession.
So that's our primary argument on the transitional provisions.
Yeah.
We have a fallback argument. So if it is permissible under the statute to say that the relationship is unfair because of an historic related agreement which has no effect on the current relationship, then the court has to decide what is meant by Schedule 3, paragraph 16, which excises the words by virtue of the related agreement in section 140B. Now, it is common ground, I'm sure my learned friend will correct me if I'm wrong, that the relationship after 6th of April 2008 is said to be unfair because of the unfair PPI policy that had ceased to have any operation before that date. And they accept that section 140B has to be read as if the words by virtue of any related agreement had been excised. So in other words, if one looks at 140B, which is at bundle 1, look at 140B 1A, because the PPI policy ended before the 6th of April 2008, or ceased to have any operation before that date, one reads section 140B 1A as if references to related agreement were not there, so that the remedies that the court can order are simply to repay any sum paid by virtue of the credit agreement, not the related agreement. And that is because of, as I say, Schedule 3, paragraph 16, 4 and 5, which I've taken the court to, and I won't do so again unless I have to, but that basically says excise those words if you have a related agreement that ends before the 6th of April 2008. It's common ground that they ceased to have operation before the 6th of April 2008. Both policies ended. There's nothing referable to them on the credit cards. In those circumstances, it would be very odd in our submission if the sums that were paid under those PPI policies could now be recovered. That would be contrary to the policy of the statute, which gave lenders a year to sort out their relationship, get rid of the unfair ones.
Can you tell me what, absent any reference to PPI, the courts have found to be examples of an unfair relationship? To see how often this particular section, absent or regulated agreement, would bite.
Other examples, for example, extortionate rates of interest is a common claim.
So, in those circumstances, if someone post 2008 comes before the court and says, "Look, I've got this credit card and it's charging me X plus 10%," that shows it's an unfair relationship, and therefore you can order to be repaid the whole of the sum on my credit card.
Well, what they would ask in that situation, in my submission, would be for an order that the bank repays the interest, which was larger than it should have, which was unfair. As a matter of reading the remedies, as a matter of black and white English, the court could order the discharge of the whole balance.
Yes, the only reason I'm asking,
Yep.
Mr. Taylor, is to test your proposition that you take away all regulated agreement and there'd still be bite in this provision.
Oh, there absolutely would.
Yes, that's why I'm
absolutely,
asking.
Yes, absolutely. Yeah, if this credit card agreement, the two that are still in existence, had an extortionate rate of interest, absolutely, the claimants could come to court.
So Ms. Smith and Mr. Burrell could have made
Absolutely,
that.
they could come, a whole range of remedies that they could have for these ongoing credit cards. If,
under these provisions.
under these provisions,
Yeah.
absolutely, yes.
That's
yeah.
the only reason I'm asking.
All right, all right. Now, the effect in our submission is when one reads section 140B1A without the words "or related agreement" in there, is that one cannot recover the sums which were caused by the PPI agreement itself. So the premium that was paid for the PPI cannot be recovered because that was paid by virtue of the related agreement. And those words are excised. That's something the court cannot order. Now, what my learned friends say is, well, yes, we'll accept that the PPI premium was paid by virtue of PPI policy. We'll accept that. But they say, but it was also paid by virtue of the credit card, and therefore we can make a recovery. And we say that that would, again, drive a coach and horses through the legislation, giving a remedy when the unfair agreement had been brought to an end prior to 6th of April 2008. And what's created confusion in this case, in our submission, is that one has confused what caused the PPI policy, premium to be paid, which is the PPI policy, the contractual obligation to pay the PPI policy, with the means by which that premium was paid. It was paid by the credit card, it was on the credit card, but that was just simply the mechanism of making payment. What these provisions are aimed at is ascertaining, well, what agreement caused the payments to be made, by virtue of which agreement were these payments made. And we say, well, it's quite clearly by virtue of the PPI policy, which has now come to an end before the 6th of April 2008. And because it's come to an end, you can't order those payments to be made because they were made by virtue of the related agreement. And the point may be illustrated by considering a situation where the PPI premium was not paid by the credit card. Let's say the PPI premium had been paid on a bank account. It wasn't paid on the credit card. It's the customer funds PPI premium on a perfectly fair bank account. They incur some interest on that bank account because they go overdrawn when they make their PPI premium payments. Now, if the PPI policy, and the PPI policy is to insure the credit card debt, if the PPI policy started and ended for the 6th of April 2008, it would have ceased to have any operation for the end of the transitional period. That's Schedule 3, paragraph 16.5, with the consequence that no remedy could be ordered under Section 140B. So no premium or interest incurred on the overdraft could be recovered. In the words of Section 140B1A, PPI premium and any interest incurred on funding that premium would have been paid by virtue of the agreement, i.e. by virtue of the PPI policy. Now, just because a customer happens to pay their PPI premium on a credit card shouldn't change that analysis. The PPI premium and interest has been caused by the PPI policy. It is by virtue of that PPI policy that the premium and any interest incurred on it has been paid.
Out of interest, did they have a choice?
Sorry, my lord.
Well, you said it just so happens that they paid the PPI premium through the credit card. I thought they didn't have a choice. That was the way it was set up.
That's right, my lord. I'm trying to illustrate. That's absolutely right. I'm just trying to illustrate how we say not only the premium, but also the interest on the premium is paid by virtue of the PPI policy.
Well, this is your version of the timeshare example.
It is.
In the sense that what you're talking about, the point you're making, which I understand, is that you can have payments which are made by virtue of the related agreement, which don't go through the credit card agreement. And you're saying that those must be taken away by this provision, this chop-out provision.
Yes. Yes.
And I mean, that makes sense to me. And that's the point of the timeshare example that was given, because the timeshare example involves some part of the timeshare being paid through the credit card and some part of the timeshare not being paid through the credit card. And if it all happened today, both sums would be caught. But the point that what's put against you is that the excision in the transitional provisions, they say, would take away the bit of the timeshare which wasn't paid through the credit card. That's what they say. And you're giving an example, your version of the related agreement example is another example where the PPI premiums are not paid through the credit card. And I don't think anyone disputes that those payments would be taken away by the excision in the transitional provisions. But the point that's put against you is that you, your client, chose to make the PPI premiums paid through the credit card agreement, and therefore they're not just paid by virtue of the related agreement, they're paid by virtue of the credit card agreement. That's the That's the finding that was made by the judges.
Well, Lord, that involves a proper construction of the words by virtue of the related agreement. And when one construes those words in our submission, one has to bear in mind what these transitional provisions were trying to achieve, which was, if you get rid of your unfair agreements before the 6th of April 2008, then you will not face claims under Section 140A to B. We got rid of the PPI policies in this case. And to give effect to the policy of this legislation, one construes the words by virtue of the related agreement as meaning that it covers the sums paid under that agreement, the contractual obligation to pay under the PPI policy, and so is not recoverable under Section 140B1A.
And you say it would also exclude a payment which was a payment by virtue of the related agreement, but was also a payment by virtue of the credit card. You say it's excluded by that because what by virtue really means is caused by.
Yes, my lord.
Well, I get it. I understand.
Now, just finally on this point, one of the points that we rely on in support of our construction of Section 140B1A and the excision of the words or any related agreement is, as we saw in paragraph 16.4 of Schedule 3, the court can't order an account in respect of a related agreement that is ended now. As we all know, an account is intended to look at the payments that have been made over a period of time between two parties in order to come to a final balance, a net sum which might be owed by one to the other. Now, if it had been intended that sums paid by virtue of a related agreement that had ended, if it was intended that those sums could be recovered, then the remedy of account would not have been expressly excluded. So, in my submission, it cannot be disputed that the court simply could not order an account between the bank and the customer of what was paid towards the PPI. That's just simply not possible because of the very clear terms of paragraph 16.4. You just cannot order that account. Now, that gives, in my submission, a very clear indication that it was not intended that the sums paid by virtue of that related agreement could be recovered at all, in any way. So, just to conclude this section of my submissions, firstly, the court should hold that there was nothing unfair in the relationship after the 6th of April 2008. So no claim for PPI repayments can arise under section 140A. Alternatively, PPI and interest were paid by virtue of the PPI policy alone and are irrecoverable as a result of Schedule 3, paragraph 16.4. Those are my submissions on the first point. I was now proposing to move on to limitation.
Thank you.
It is common ground that both the claimant's claims are governed by Section 9 of the Limitation Act. Both are to recover a sum pursuant to an enactment, i.e. Section 140A to B. The claimant's case is encapsulated in their skeleton in the Smith decision, the Smith skeleton, paragraph 4D, where it says, in terms, the cause of action accrued in 2015, as that is when the credit agreement came to an end.
So did you say 15?
It's paragraph 4D.
4D, I'm so sorry. Thank you.
The Smith skeleton, where it says, the cause of action accrued in 2015, as that is when the credit agreement came to an end. In our submission, that is a misconceived argument, which is inconsistent with a long line of House of Lords and Court of Appeal authorities on how and when a cause of action accrues to recover a sum of money under statute. As we set out in our skeleton, paragraph 42, cause of action is simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against the other. As we say in paragraph 43 of our Smith skeleton, the cause of action to recover money under a statute accrues on the date when the claimant would be able to issue a claim form setting out every fact necessary to support his right to judgment. In the context of a claim for repayment of a sum paid by virtue of an unfair agreement, the facts are, first, those necessary to show there was an unfair relationship, and secondly, that the customer made a payment pursuant to the unfair relationship. And let's assume that a borrower makes such a payment. So, to take a lady's example, there is a credit card which has an extortionate rate of interest. The customer pays that extortionate rate of interest at the end of the month. The customer could then immediately issue a claim form claiming that the relationship is unfair and asking the court to order under section 140B1A repayment of that sum that had been paid pursuant to the unfair relationship.
But presumably they could also issue that claim at any other stage if they continue to have the credit card, because that's the agreement that continues, and that's where the unfairness has arisen because of the extortionate amount of interest.
Well, lady, whilst the agreement may continue, the cause of action to recover a sum of money accrues on the date that you make that payment.
Well, I appreciate that, but they could make that claim subsequently
They could make that claim.
on the basis of section 140.
They could make that claim for a period of up to 6 years after they make the payment.
Well, doesn't it say 6 years after the end of after either the completion of the agreement or that it ceases to have any effect? And on the example that I used, the credit card itself charging the extortionate amount of interest, surely that falls within those provisions.
No, lady, in my submission, the provisions on which we've been looking at for transitional provisions about completed agreements and the like, they have no bearing on the question of when a cause of action accrues to recover an unfair payment.
And there were no bespoke limitation provisions. There's the transitional provisions, but there were no bespoke limitation provisions in the Act.
That's absolutely right, my lord.
Because sometimes you see with statutory legislation which is giving rise to a particular type of claim which might be slightly unusual. I mean, in one sense, an unfair relationship is a slightly unusual sort of concept. But there are no limitation provisions dealing with that. So you're sent back to section 9 and 6 years from when the cause of action accrued.
That's right, my lord. So I was proposing just to run through some of the cases on section 9 to illustrate the circumstances in which it's been applied, the wide circumstances in which section 9 has been applied to a claim for recovery of money under a statute, and also to show that this has been the law for well over half a century. And one of the points I'll be making, and we make in our skeleton, is if a different limitation period had been intended in relation to section 148C, as my Lord Justice Coulson said, well, one would have expected to have seen some bespoke limitation provisions if we were going to depart from the established law as to when a cause of action accrues under section 9 of the Limitation Act. So it's common ground between the parties that in determining whether section 8 or 9 applies, one has to look at the remedy that is being sought. And if we just turn up the Limitation Act, which is at tab 2.
You say that it's conceded that section 9 applies.
Yes.
Do we need to?
I'm very grateful that...
Do we need to go to section 8?
No, I'm very grateful. Well, the first case then would be Hill and Spread Trustees, which is at the First Authorities Bundle, tab 19. Now, this was a case arising out of section 423 of the Insolvency Act. There's a claim by a trustee in bankruptcy that the bankrupt had transferred his land and his rights under a loan to a trust for the purposes of defrauding creditors. And if one looks at the head note under subparagraph H on page 337 of the bundle, we have the proposition which is not controversial, that whereas that the period was either 12 years under section 8 if the claim was a claim on a specialty, or any other case 6 years under section 9 on the basis it was a claim for a sum recoverable by virtue of an enactment. So this is an illustration of the fact that where a statute provides different remedies, then the limitation period applicable to those remedies depends on whether the case falls in Section 8 or Section 9. And it's common ground that a claim for repayment, where you're seeking repayment as a remedy, is Section 9 and subject to a 6-year limitation period, not Section 8, which has got a 12-year limitation period.
As I say, I don't think this is an issue, is it?
So, what is instructive about this case, in my submission, is looking at the way in which Section 423 was structured, and that's at page 373. And I might invite the court, please, just to read. It's at the bottom page of page 373, paragraph Section 423 of the Insolvency Act. It's the first 3 sections.
I'm sorry, Mr. Taylor, I missed the reference.
Right, it's
where are we?
So it's Authorities Bundle 1, tab 19, page 373.
On the paragraph?
And it's right at the bottom where it's just the provisions of Section 423 of the Insolvency
Oh, I
Act.
see. Sorry. You're not looking at the judgment, you're looking at the appendix.
Yes, sir. Yes, sir.
Sorry, I got you now. I was looking at bits of judgment, couldn't see it.
This is just to illustrate the structure of this Act of Parliament, which in our submission is very similar to the structure in Section 140A and B.
Right, okay.
So, the way this particular cause of action is structured in Section 423, subparagraph 2, is where a person has entered into a transaction at an undervalue, the court may, if satisfied under subparagraph 3, make an order as it thinks fit, or restoring the position to what it would have been if the transaction had not been entered into, and protecting the interests of persons who are victims of the transaction. Subparagraph 3 requires that there has to be a mental element, which is what the intention was to put the assets beyond the reach of creditors effectively. But if those conditions are satisfied, then the court may order, and one then drops down to Section 425 of the Act, right down at the bottom there, which lists out a whole range of remedies that the court can order. So it can order, for example, transfer of property. It can release or discharge security. D, it can require any person to pay to any other person the benefits received from the debtor, such sums as the court may direct. Now that remedy of ordering somebody to make a payment is subject to Section 9 Limitation Act. It doesn't matter that the court has a discretion as to whether to make an order for payment, and if so, in what amount. As Lady Justice Arden said at paragraph 115H, at the bottom. However that may be, I do not see how it can be said that in the case the 1980 Act provides no limitation period. That was one of the arguments in the case. Of course, the court has jurisdiction to make some form of order other than the payment of money, but it is established by earlier decisions of this court that where the statute enables the court to give relief in monetary or non-monetary form, the court must the court should look to see what is actually claimed. Now, there's no dispute that in this case, all that's claimed, the only remedy, is a repayment. The next case, another illustration of how Section 9 is applied, is the case at tab 12, page 181 of this bundle. The Farmers are Products. It's a judgment of the Court of Appeal given by Peter Gibson, with whom Lady Justice Butler-Sloss and Lord Justice Potter agreed. And this was another provision of the Insolvency Act, Section 214, which we can see at page 183 of the bundle. Right down at the bottom, where it says at H, Section 214 is directed against wrongful trading. It was first introduced by Section 15 of the Insolvency Act 1985, which came into effect on the 28th of April 1986. It is in this form so far as material. If in the course of a winding up of a company, it appears that subsection 2 of this section applies in relation to a person who has been a director of a company, the court, on the application of the liquidator, may declare that the person is to be liable to make such contribution, if any, to the company's assets as the court thinks proper. And the conditions are that the person was trading when they knew or ought to have concluded there was no reasonable prospect the company could avoid going into insolvent liquidation. Now, it was argued that the words, if in the course of a winding up of a company, provided the date when the cause of action accrued. So it was argued that, well, it depends when the liquidator comes to that view. That's when the cause of action accrued, and that was rejected by the trial judge, Mr. Justice Blackburn, and we see that at page 659. It's at paragraph D on page 659 of the internal of the report reference and 185 of the bundle. And it was pointed out that the cause of action accrued on the date when the company went into liquidation. And if only later the liquidator came to the view that there was a basis for a wrongful trading claim and commenced proceedings, that fact would not be material to determination of the date when the cause of action arose. And a similar point can be made in respect of the Smith and Burrell cases, that what's said here is, well, the cause of action accrued on the date when the credit card agreements came to an end. But that date's irrelevant to when the cause of action accrued, just as it was irrelevant in re Farmers as to when the liquidator came to the view that they had a claim. The claimants in these proceedings could have sued at any time. They could have issued their claim form on the 6th of April 2008, while the agreement was still on foot. So the date
that paragraph you've taken us to is the judgment at first instance.
Yes.
So how did Peter Gibson LJ deal with it?
Well, it looks as if that point was not even run on the appeal. So it was dismissed by the judge. What they ran on appeal was that there's no limitation at all applicable to this section, and that also was rejected.
Right, okay.
And in fact, that's rejected at paragraph 660A to B.
So this point, which wasn't run on appeal, has only ever been decided. So you've referred us to
Yes.
authority from the Court of Appeal, but it doesn't deal with this point
It's
directly.
that's right, my lady. It's Mr. Justice Blackburn's decision, which wasn't in fact appealed. That just finding that wording in the statute in that case did not displace the usual rule that a cause of action accrues when all the facts necessary to bring the claim are established. And it's neither here nor there when the liquidator thinks he's got a claim. What's important is what are the facts that need to be established in order to bring a claim under section 214.
Yes, I understand that. It's merely to say that this is reported by the Court of Appeal, not explicitly endorsed.
Well,
That's what I'm trying to get
yeah.
at. Is there anything in the judgment that lends support to the judge at first instance on that view?
Well, only that that was one of the arguments that was run, which was dismissed by the judge at first instance. It wasn't pursued in the Court of Appeal. Other arguments were, which were also dismissed by the court.
I understand that. Is
So-
there anything in the Court of Appeal's decision which endorses that view?
Only the reference to it.
If there isn't, there are other cases you're going to take us to. It's just that
Yes.
sometimes that we're overtaken with citations which really don't necessarily support the point as may first appear at the level that first appears.
Sorry, lady, yes, I'm grateful to Mr. Robertson. It's at page 661.
Thank you.
See.
This is the second paragraph, is it?
No, so it's page 661. C. It's the third paragraph before I leave this point.
Right. I therefore have no hesitation in dismissing this argument. By the by, some of these authorities comply with the practice direction of outside lining and some don't. Just to
I
take
do
away
apologise,
with you.
mate.
No, it's okay, just to take away with you for
Yep.
future reference.
Now, the other point, which in my submission we get from this case, is at page 660, A to B. And this was in response to another argument that was run that was along the lines, there is no limitation period applicable to this particular cause of action. And if I could just invite the court, please, to read the first paragraph. And of particular relevance in my submission is the sentence, it must be assumed that when Parliament enacted Section 214 and its predecessor in the Insolvency Act 1985, it did so conscious of the provisions of the 1980 Act. And that applies to this situation, the case before us. Parliament must be taken to have known the long line of House of Lords and Court of Appeal authorities which state that a cause of action to recover money accrues under a statute when a claimant is able to plead all the facts needed for the remedy they seek. Finally, on this case at page 189, it's page 188 where it starts. Right down at the bottom, the very last two lines. Does the fact that the court has a discretion whether to make a declaration at all, even if it appears to the court that subsections 2 of section 214 applies, and to the amount of the contribution, if any, calls a claim made not to be an action to recover any sum recoverable by enactment. I do not think so. If I could just invite the court to read until the end of that paragraph. The short point is the fact that the sum that may be recoverable is in the discretion of the court does not mean this is a case outside section 9. It is. The next case is the in Authorities Bundle tab 1, which we're in at tab 14, the decision of Court of Appeal, Linda Borough, London Borough Council and ARC Limited. It's a decision of Lord Justice Potter with the Lord Justice Norse and Mummery agreed. And this concerned a claim for compensation against a council who had compulsorily purchased acquired the claimant's property. The claim for compensation was found to be time barred. And the relevance of this case, in my submission, is that it was decided in 1999, and it neatly summarises over 5 decades of case law that have taken on the same approach to limitation, where the statute permits a claim for money to be made. And it refers to a wide range of statutes where the same approach has been taken. So if we look perhaps at the judgment of Lord Justice Potter at paragraph 25. Paragraph 25, it seems to me that a number of authorities make clear that, for the purposes of limitation, a cause of action may accrue for any sum recoverable by virtue of an enactment, although the sum is yet to be quantified by some process of agreement or adjudication. In paragraph 26, Lord Justice Potter referred to the Pelger case. That was a 1948 House of Lords decision. We've cited it in our skeleton at footnote 9. As we say in our footnote, it doesn't matter that the claim can't be quantified at the time the claim is issued. Paragraph 29 to 30 Lord Justice Potter referred to a case of Central Electricity Board and Halifax Corporation. That's a 1963 House of Lords decision. Again, it's referred to in our skeleton at paragraph 43.1, but it's applying precisely the same approach, albeit to a different statute, that we say applies in this case. When did the facts arise that the claimant could plead in order to obtain the monetary relief they claim? Paragraph 31 refers to the Farmer's case that we've just looked at. At 31, Lord Justice Potter said, finally, a striking example of the width of the court's approach to the definition of action to recover any sum recoverable by an enactment is afforded by the recent decision of the Court of Appeal in Re Farmer's. If I just invite you to read to the end of the quotation. then over the page, at 153, having reviewed those House of Lords authorities, which date back over 50 years, when considering the provisions of Section 11 of the Act of 1965, that's the statute that he was dealing with, in the light of the authorities above cited, it does not seem to me that there is good reason to construe Section 11 as giving rise to a cause of action within the meaning of Section 9 only upon the agreement of the parties or the award of the Lands Tribunal. In my view, the requirements of Section 6 of the Act, that the question of the disputed compensation shall be referred to the Lands Tribunal, is properly to be regarded as a procedural provision whereby the right to compensation is referred to for quantification rather than as an essential step without which the cause of action in respect of the compensation is inchoate or incomplete. And then just at 34, 4 lines down with the sentence, thus the right or cause of action which arises on entry by the authority may properly be characterised as a right to be paid such compensation as may be agreed or assessed by the Lands Tribunal. And then finally, on this case, just the judgment of Lord Justice North, they have a short judgment at the end on page 219 of the bundle, 157 internal. Which is a useful summary of the claim. It doesn't matter that the amount claimed has got to be the subject of an assessment by somebody else. In this particular statute, the cause of action accrued as soon as the council had entered into the property and the right to then seek compensation arose. It was then that all the facts necessary to bring the claim had arisen. And that is, as I say, a consistent approach across a variety of statutes for half a century, covering a vast array of statutory provisions, including the Land Compensation Act, that's the Hillingdon case, Section 214 of the Insolvency Act, that's Re Farmers, Section 423 of the Insolvency Act, that's Hill, the right of an electricity company to seek payment from another electricity undertaking, that's the Electricity Act, that's the House of Lords decision in Central Electricity in Halifax. And I would just add, although not of Court of Appeal or House of Lords authority, under the extortionate credit bargain legislation, there was an obiter judgment in Nolan versus Wright, which we referred to in paragraph 43.3 of our skeleton, where under the extortionate credit bargain legislation, there was one of the remedies, an ability to ask for sums to be repaid, and obiter, it was held that the cause of action to recover that sum arose when the payment was made. That's paragraph 43.3 of our skeleton. Now, in our submission, there is no justification for applying a different approach to this case under the unfair relationship legislation. Parliament must be taken to have known when a cause of action accrues to recover a sum of money under statute, see Re Farmers and the judgment of Lord Justice Peter Coulson. There is nothing in the wording of section 140A or B which indicates that the settled law concerning the limitation period for recovering a sum under statute is any different to that which applies under these other statutes that we've looked at. Had a different approach been intended, there would have been clear words in the statute. There are none. And academic opinion supports the bank's case. The Encyclopedia of Consumer Credit Law, it's at Bundle 2, page 669.
Sorry, I was just noting noting down something else. What was the reference again?
Sorry, Lord, that's bundle 2, page 669, which give you the tab references, tab 30, page 669. This is an extract from Encyclopedia of Consumer Credit Law, edited by Eva Lomnicker and Guess, which supports the view that the 6-year limitation period to recover a payment made in an unfair relationship commences on the date of payment. And the relevant paragraph is highlighted. I might invite the court to read that paragraph.
This is the one that starts as to when the cause of action accrued.
Sorry, as to when the cause of action accrues.
Right, on 669.
It's on 669, yes, that's the...
With 2 paragraphs.
So it starts with as to...
It starts with
Yes.
that my lord's just read, and then there's the reference to Patel, which is the
that's
decision of George Leggett, Queen's Counsel, as
Yes.
it then was.
that's up to... Those are the 2 paragraphs, Lord, yes.
Yeah.
So the view expressed by the editors is that it would appear that Limitation Act 1980 applies where repayment sought, and the limitation period is 6 years from the date of repayment.
But George Leggett QC, as he then was, thought that it was a claim was an action on a speciality, and therefore limitation was 12 years.
Well, I'm going to come on to Patel.
I was going to say that's where we're going, isn't it?
It is.
Before we do, it's 1:45.
Yes,
Can you tell me how you're doing?
I can. So I am at least 2/3 of the way through this, my submissions. And we have got, in terms of the cases that I would like to take you to, I've got to go through Patel and the Scotland case, and a very brief mention to Wood as well.
So how long do you think you're going to take?
I would hope that I can get through this in half an hour.
Okay, so you'll just go over lunch.
Well, we'll be
Yes,
going
yes.
to...
It's my clumsy way of expressing this. We will rise at 1 o'clock,
I see, yes.
so that you'll come back and you'll finish shortly after our return.
I will, my lady, yes. If it's slightly more than 15 minutes, then I do apologise.
Well, we'll obviously give you a proportionate leeway, but we must make sure that we hear from Mr. Weir, of course.
Absolutely.
Yeah.
Okay. So if we turn up Patel versus Patel, which is at Second Authorities Bundle, tab 22. So just to summarise what we say about Patel, First of all, it's a case on Section 8 of the Limitation Act, which concerns an action on a specialty. It did not consider Section 9. Secondly, the facts in Patel are completely different to the facts of this case. There was ongoing unfairness in the relationship at trial. The lender, in that case, was seeking judgment for £6 million, a sum that was generated on an ongoing extortionate rate of interest that was compounded monthly. The court...
Because the loan started off at about 200 grand.
It did. It was an extraordinary set of facts.
Yeah.
Absolutely, yes. If, contrary to those submissions, Patel was seeking to set out the law as to when a cause of action to recover a sum of money accrues, then we respectfully say it was wrongly decided. And we have a fourth alternative argument that, well, if Patel is correct, that this is the approach to Section 9 cases, then the cause of action to recover a sum of money accrues at the end of the relationship, according to Mr. Leggett, QC, and that must be in the end of the unfair relationship. And on the facts of our cases, the unfair relationship arising out of the credit agreement taken with the PPI policy ended when the PPI policy came to an end, 6 years before issue of the claim form. So those are the 4 points we make on Patel. Turning to the facts, it was a family, there were 2 family members who'd been friends for over 50 years who entered into a loan transaction together. The first 2 loans had been made in 1983 in the sum of £56,000. One was to purchase a newsagent and one was to purchase a supermarket. Those loans, by the time it got to 1992, had come to, as Lord Justice Coulson said, around about £200,000, and that's apparent from paragraph 27 of the judgment. Now, paragraph 27 sets out the terms of the oral agreement that was made on the new loan that was going to take effect from 1992. And as one can see there, that interest would accrue on all outstanding sums at a rate of 20% per annum, compounded monthly, with effect from the 1st of July 1992. And that the amount outstanding at that date, which the judge found to be a fair amount, was £207,465. But after that, interest accrued at 20% compounded monthly. Paragraph 54, for your note, shows that those were the terms that the judge accepted had been agreed. Paragraph 73 judge said that after 1992, the relationship became progressively more unfair to the borrower. And one example of that, that's paragraph 73 sub 4, which is on page 426 of the bundle, 885 internal references. As interest rates have fallen, the rate of 20% charged by the claimant has become more and more exorbitant. In January 1993, the Barclays Bank base rate fell to 6%. At the time when the 2003 document was signed, it was 3.75%. It is currently 0.5%. So as the relationship was going on after 1992, the rate of 20% compounded monthly got more and more unfair as bank base rates came down. Paragraph 74, the judge held that the lender's conduct up to trial, quotes, very substantially increased the unfairness of the relationship. And there are a whole list of matters that were that occurred in the run-up to trial. And I can summarise them. There's no written record of the loan. When there was for 11 years, when there was a written record, no copy was provided to the borrower. For 15 years, there were no statements of account. And the high rate of interest, which was compounding monthly, was grossly unfair, particularly when no statements were being provided to show how that balance was increasing. The loan was in fact only demanded some 16 years after it had been agreed, and that's clear from paragraph 47, which talks about the letter of claim being made. And as at the trial, the lender was positively seeking judgment for a sum of £6 million, that's apparent from paragraph 1. That was based on the continued accrual of unfair compound interest month after month after month leading up to the trial. In fact, the sum that was being claimed increased from the claim form to the sum that was being claimed at trial. Now, first point, Patel was not a Section 9 case. The primary remedy sought by the borrower was the reduction of the outstanding loan balance of £6 million as at the date of trial, and we see that from paragraph 67. The parties, given that they were seeking a reduction in the balance, it was an action on a specialty governed by Section 8 and a 12-year limitation period. And the parties agreed it was a Section 8 case, not a Section 9 case. We see that agreement in paragraph 58 and 61, which the judge refers to the acceptance by counsel. This is a Section 8 case. Now, the argument that was run at paragraph 60 was based on the extortionate credit bargain legislation, and it was said that as the agreement under which the claim is in this action is brought was made in 1992, which is more than 12 years before the action was commenced or the defence was filed, the defendant's claim for relief is time barred. That was the argument that was run. And it's not surprising that that argument was dismissed because we've seen all of the facts that continued after that loan agreement was made, which made the relationship unfair every day running up to trial. The fact that the balance kept on being increased month after month by 20% compound interest, rising, even staying at that level even when interest rates came down to 0.5%. In circumstances where, although the balance was escalating massively, the borrower wasn't even given a statement every month to show this is what you owe. So it's not surprising that that argument was rejected by the judge. As at the date of trial, £6 million was being claimed. The judge had jurisdiction under section 140B to reduce that balance, which he considered to be unfair. So Mr. Leggett QC didn't have to consider Section 9. It wasn't a Section 9 case asking for repayment. It was a case, please can you just reduce down the sum that my creditor is claiming from me. He's claiming £6 million, please reduce it down. And in fact, that is what the judge did in that final paragraph of his judgment at 84. He reduced the claim for £6 million down to £207,465. So our primary submission in relation to Patel is it's not a Section 9 case, and the court should apply the House of Lords and Court of Appeal approaches to Section 9, which I've outlined earlier on this morning. My second point is Patel is completely different on the facts. As I said, there were matters which continued from one day to the next, right up until trial, which in Mr. Leggett's words at 74 very substantially increased the unfairness of the relationship. And this included the act of compounding interest every month, increasing the balance, and not giving the borrower any statement of account. So when one was looking at the words of section 140A, 1, C, there were acts and omissions that happened each day of the relationship, making that relationship unfair. New acts and omissions that were happening right up until trial, as the creditor was increasing his balance that he was claiming.
Did the reduction in balance include a reduction in a balance which had accrued more than 12 years ago?
Yes, it did, my lord. It wasn't argued that there was any limitation problem with that. We've seen what the limitation issue was. It was you can't do anything because we're 12 years after the agreement. So, as I say, the court determined that, as at the date of trial, the amount being claimed was unfair, and it was reduced down to 200,000 from 6 million. Our facts are completely different to those in Patel. No part of the credit card balances was referable to PPI premium after April 2006 in Mrs. Smith's case and March 2008 in Mr. Burrell's case. There's no claim to reduce an unfair balance as there was in Patel. There were no continuing acts and omissions which caused any unfair payments to be made within 6 years of the claim form, in our case. Instead, Mrs. Smith and Mr. Burrell have to go back more than 13 years, and in fact, in some cases, more than 20 years, to point to the acts and omissions which they say give them a remedy for repayment of monies paid under the PPI policies. Those claims are time barred under the long-standing House of Lords and Court Appeal authorities I've referred to. So Patel can be distinguished on the facts, as well as not dealing with Section 9.
Well, it does in paragraph 66, doesn't it?
Well, that is what I'd like to come on to next, Mate. You're absolutely right. I do need to deal with paragraph 65 and 66. If I could just invite the court to read 65 and 66, please. Now, the first point to make on 65 and 66 is what in my submission was a clear typographical error in the reporting of the case, where 66 refers to Section 9. That should be Section 8 in my submission, because Mr. Leggett was not dealing with a case under Section 9, as we've seen. It was purely a Section 8 case seeking a reduction of the balance.
Well, why do you say that when at the end of that paragraph he specifically refers to Section 8, subsection 2 and Section 9, subsection 1?
Well, what he is referring to two sections at the end of his judgment, that the case concerns Section 8, and what he said about Section 9 at the end there is obiter, because there was no claim for repayment of any money.
Is there any other basis for you saying that there's a typographical error in the first line of paragraph 66? Well,
the basis is that the claim was solely for reduction of the balance, which everyone agreed was an action on a specialty.
So if you're right, then that's fine. You made the point. And if you're not right on that, you say it's obiter.
Anything said about Section 9 is obiter, absolutely.
Yeah.
Yes.
So one way or another, you're saying that we can't rely on Patel.
Well, my lord, I'm saying that A, it's obiter, but B, as I'm going to come on to now, this analysis is in our submission wrong as regards a Section 9 limitation point.
Which is the bit that you say is wrong?
Well, first of all, as we see from paragraph 66, the cause of action was described as a continuing one which accrues from day to day until the relevant relationship ends. So he said it was a continuing cause of action. A continuing cause of action has no application to a case where the remedy being sought is repayment of sums paid in the past. The correct analysis is that cause of action accrues when all the facts, when the claimant can plead the facts necessary to support the order for repayment. And that requires the pleading of the specific payments that were made. It's not right to describe those individual payments as a continuing cause of action. They are individual causes of action each time a payment is made. But it's also important to understand what is actually meant by a continuing cause of action. All it means is that there is a repetition of acts or omissions of the same kind that give rise to the cause of action being sued on. And so, as we set out in paragraph 60, sub 2 of our skeleton, we cite there the case of Hole and Chard, which in my submission is a very helpful definition of what is meant when one says a continuing cause of action. It doesn't mean that there is one cause of action. What it means is that there are a series of events of the same type that give rise to a new cause of action each time the event occurs. Now,
Like continuing nuisance, say?
Exactly. Well, that's exactly my next point was the best analogy would be a continuing nuisance, much like the oil spill that your Lordship had to consider recently.
And is that a convenient moment at the point of the oil spill?
Yes, lady.
Absolutely. Yeah. We will return at 2. We're going to obviously be understanding of a little overrun from what you've said, but we do have to rise at 4:15 today. So, Mr. Weir, I should ask you if you were able to start at, say, 2:20.
Well,
Does
it's,
that
al-
give
it's,
you
al-
a
it's always
fair
difficult to complain, and we have made our submissions in writing, and sometimes brevity may assist me rather than the other way round. But I am being compressed. About that, there can be no doubt. My learned friend has gone for 2.5 hours so far, 2 hours and 35 minutes. The invitation now is to extend that by 20 minutes to 2 hours and 55 minutes. To allow him a reply, I don't know how long for, even if it was only 5 minutes, would be 3 hours, and I would be being allowed less than 2 hours.
Well,
I understand, my lady.
I think the question was, will that be sufficient for you?
My lady, my response was intended to say it's whatever I say. It seems that the die is cast. I will of course endeavour to compress my submission since the time available to me, but I am struggling as time slips beyond 2:15, my lady.
Well, we don't want you to be under any prejudice, and obviously if you have an application to make in due course, we'll listen to it, but this was a time estimate that was supplied by the parties.
my lady, yes, and would normally be divided relatively evenly, and so far that's not the way
Depends on the,
not the way matters are panning out, my lady.
well, it depends on the arguments to be made and the manner in which they're made, I think. But let's see how we go. Mr. Taylor, you've heard what Mr. Weir says. So, we're not going to let you go beyond 2:20. Perhaps you better choose your best points for the next 20 minutes maximum.
All right.